I'm Michael Waldman. I'm the president of the Brennan Center for Justice here at NYU School of Law. And we began 16 years ago, as most of you know, founded by the clerks and family of the late, great Supreme Court Justice William Brennan, whose memorabilia, some of which is in the back, including the chair, which you're not allowed to sit in. Only at the holiday party do we do that. And the Brennan Center, from its beginning, has focused on the systems of democracy and justice, on the systems that give voice to ordinary citizens and that make our government work effectively and that honor the structures and strictures of the Constitution. And so it's not surprising that shortly after the Brennan Center's founding, when September 11th happened, just a mile to the south, that we began looking at issues of how the U.S. government responded to that tragedy and that atrocity. And the focus of our work, more than anything else, revolved around this issue, the issue of the proper role of the presidency, the proper checks and balances. And that should be brought to bear even in the necessary fight against terrorism. We have a strong liberty and national security program that continues to this day. Faiza Patel is co-director of that program. Wave your hand. That's her. And we continue, as we've broadened this work to focus on domestic counterterrorism and other issues, to continue to look at this. And I'm especially excited about this program because this is a really tough issue. This is a tough issue for those of us who believe in a strong government. It's a tough issue for those of us who believe in a powerful presidency. And it's very important that progressives have a consistent and coherent view on this that doesn't depend on it being someone we like and not Dick Cheney sitting in or near the Oval Office. At least that's what some of us think. So I'm really eager to hear this conversation and eager to hear from and turn over the mic to a colleague. Caroline Fredriksen, as you know, leads the American Constitution Society. It is a partner, a colleague, and a tremendous resource for all of us here in New York and around the country, and it's great to welcome you and your colleagues here.
Thank you so much, Michael. I'd like to thank the Brennan Center, Michael and Faiza, particularly for helping organize this program along with us. We are very grateful to be here, and the Brennan Center is a fabulous coalition partner for ACS, and we work very closely with the Brennan Center on a host of issues. Obviously, executive power, national security issues among them, but also voting rights and criminal justice matters, as well as a number of other things. And so we're very, very thankful that you're working with us on this. The American Constitution Society, for those of you who don't know us, I hope you all do, and if you're not members, you will join. We are a national network of law students, lawyers, law professors, judges, and policymakers that works to make sure that the law helps to improve the lives of all people. We obviously have a mission that's very much in sync with the Brennan Center and with the vision of Justice Brennan. We're here tonight for what is the third in a series of programs that ACS has been holding this spring that we have been calling our intra-progressive debates. And these are conversations that are helping to identify common ground through the exploration of fault lines within the progressive community on important topics of the day. We are about to hold another one in DC coming up soon, which is on the proper scope of religious exceptions or exemptions. We recently held a debate in Irvine, California between Deans Erwin Chemerinsky and Larry Kramer on popular constitutionalism, which is a big dust-up, as I understand. We having a discussion on the progressive vision of federalism. So I have the very, very special pleasure tonight of introducing our moderator, Don Johnson, who probably needs no introduction in this audience, but I'll give you a little bit of a flavor in any case. Dawn is a national board member of the American Constitution Society, for which we are very grateful. She's on the faculty of Indiana University School of Law, the Maurer, okay, I knew
That's what
Maurer, okay, Maurer School of Law. But Dawn also, besides being an incredible academic, has had a distinguished career in Washington, D.C., where she served in the Department of Justice under President Clinton as the acting Assistant Attorney General in the Office of Legal Counsel, which, as you know, is where all the big thinking takes place for the federal government about constitutional issues. Sometimes bad thinking can take place there, as we know. And John Yoo was mentioned in an earlier conversation, and so you know where that happens. Dawn also was the legal director of NARAL Abortion and Reproductive Rights Action League, which is now known as NARAL Pro-Choice America. And I also had the pleasure to work there after Dawn. And Dawn clerked for Judge Richard Cudahy of the U.S. Court of Appeals for the Seventh Circuit. And she is particularly well known for her work on separation of powers issue, especially presidential power and civil liberties. I could spend many more minutes, hours, detailing all of the wonderful things that Dawn has accomplished, but in the interest of getting to tonight's discussion, I'm going to turn over the microphone. So please, let's welcome Dawn and the panelists.
Thank you. Thanks, Caroline. Thank you, Caroline. Thank you, Michael. Thanks to the American Constitution Society and the Brennan Center for sponsoring this event and for including me. Both are exceptional organizations. I've had the privilege of working with both over the years, and I just think they are invaluable in promoting public understanding of critical issues of law and policy. This debate series, what a terrific idea to have an interprogressive discussion on a series of issues on which progressives thoughtfully and in principled ways disagree. And I'm glad to be here. I'm looking forward to hearing from Marty and Steve, and it's our great fortune to have with us Marty Flaherty and Steve Hladik, both of whom are leading scholars who also have been deeply engaged in the extraordinary assertions of executive power over the last decade. Before I turn this over to them and just try to moderate their discussion and keep time, I want to just say a few words of introduction, first of the topic and then of them. So we are gathered to examine the Obama administration's approach to executive power. As the event description advertises, we'll talk about things like targeted killings with drones and indefinite detention and Libya. In addition, we are going to try to situate President Obama's positions in some historical context, especially in relation to the Bush administration's assertions of executive power and the responses that they elicited from Congress and the courts, and also consider President Obama's responses to the Bush legacy with the November election fast approaching. Think about the state of executive power for future presidencies as well. One dominant emerging narrative, I think it's fair to say, emphasizes continuity between the Obama and Bush administrations, and those on the right celebrate that continuity as somehow a vindication of the Bush administration's policies. Progressives sometimes lament what they see as inadequate change. And I just want to say, I think that the theme of continuity is important to examine. It certainly was the thrust of a New York Times article on the front page 2 days ago that some of you may have read. President Obama, the story there told us, campaigned on criticism of President Bush's disregard of Congress in the war on terror, but now we're told has shifted to a stance of unilaterally asserting and aggrandizing executive authority, just as presidents, the article said, typically do. And I just want to take a moment to say my own view of that story, I think, is that it unfortunately conflated two different fundamentally different conceptions of executive power. On the one hand, we had President Bush's claim of authority to act counter to federal statutes based on a flawed theory of executive power, for example, statutes that regulated interrogations and surveillance. On the other hand, in that story, what Charlie Savage was writing about was President Obama's determination to exercise the full extent of his statutory and constitutional powers, but with no claim of authority to violate statutes enacted by Congress. So in any event, the New York Times article, I think, was well-timed in that it reinforces the value of tonight's program. So I was glad to see that. And clearly, incredibly important set of issues. And now we are fortunate to have with us, as I said, we have the time this evening, and we have Marty and Steve. We have the expertise to go beyond the newspaper headlines. And it's now my great pleasure to introduce to you Marty Flaherty and Steve Hladik. And I want to do that in a little bit of detail, though I'll say up front that in the interest of time, I'm not going to list their impressive degrees and judicial clerkships or publications. I will say they've both written extensively on these issues we'll talk about of executive power, national security, and foreign affairs, and I really do commend their publications to you. But I want to focus just a little bit more on things directly relevant to tonight's discussion to emphasize how lucky we are to have them here. So Marty Flaherty comes from Fordham Law School, where he's the Leitner Family Professor of International Human Rights Law, co-founding director of the Leitner Center for International Law and Justice. He's also a visiting professor at the Woodrow Wilson School of Public and International Affairs. Abroad, I'm not going to tell you where he's taught here in the United States too long, but he's taught at China University of Political Science and Law and the National Judges College, both in Beijing, and Queen's University, Belfast. Marty formerly served as the chair of New York City Bar Association's International Human Rights Committee, and he has led or participated in human rights missions to Northern Ireland, Turkey, Hong Kong, Mexico, Malaysia, Kenya, Romania, and China. He is a life member of the Council on Foreign Relations, and his writings focus upon constitutional law and history, foreign affairs, and international human rights. Stephen Hladik, professor of law and the Associate Dean for Scholarship at American University Washington College of Law, nationally recognized expert on, in particular, the role of the federal courts in the war on terrorism, part of the legal team that successfully challenged the Bush administration's use of military tribunals at Guantanamo. Hamdan. Your website says successfully. So I didn't challenge that. But we'll talk about that. Co-authored amicus briefs and a host of other major lawsuits, many of which challenged the U.S. government's surveillance and detention of terrorism suspects. Steve also has drafted reports on related topics for a wide range of organizations, including the First Amendment Center, the Constitution Project, the ABA Standing Committee on Law and National Security. He's a senior editor of the peer-reviewed Journal of National Security Law and Policy, and a senior contributor to the Lawfare blog, which I commend to you as a great way of staying on top of developments, even if you don't always agree with the positions expressed there.
Or almost ever.
I often agree with your post. So, just a word about the format. We are going to ask Marty and Steve first each to speak for 5 to 7 minutes. And we're going to start with Marty. And I made this very nice sign here with a 1 on it. So you get 5 to 7 minutes. And I'll hold this up to warn you when you're reaching your 7-minute point. And then 3 minutes for responses from each. And then I'm going to moderate a conversation and pose a few questions myself for about 30 minutes. And then we'll open it up to all of you, because we know that we all consider ourselves progressives up here, but we do not claim to cover the full range necessarily on all issues of progressive viewpoints on all the issues we'll talk about tonight. So I want to hear from you and additional questions from the audience. All right, so with that, I am going to turn this over to Marty, but I'm going to just sneak over to my bag to get my iPhone so I can keep time. Can I use yours? Okay. I didn't bring it with me, and I have no watch anymore. I'll use your watch. Or give me one or the other, and then we'll be set. Whatever you prefer.
No?
We'll share it.
Okay.
All right. Okay, so thank you for being here. And,
well, great. Well, thank you, Don. Thank you to the ACS, and thank you to the Brennan Center. It's a delight to be here. I have to actually shift gears being here, because last week I was speaking on a panel at the Federalist Society AEI, so it's kind of nice to be among friendly faces. That panel consisted of, among other people, John Yoo and Jeremy Rabkin, so it's kind of right and writer, so even though I think there'll be some disagreement between me and Steve, I don't think it'll be as sharp as it was last week. But I bring that up actually to sort of give you a report from the field that dovetails with what Dawn said, because, you know, why do these things at the Federal Society and AEI and et cetera? Well, one reason is just to have an alternative voice there for whatever good it is. But another is, you know, it really gives you a kind of richer sense of thinking on the other side that you get even just beyond blogs and articles, et cetera. And, you know, the one thing I can report is the trope over and over and over again is professed love for, if not President Obama himself, for the policies of President Obama, which they view as more or less a complete vindication of everything that went before. So this is a real, you know, issue. Now, in these introductory remarks, I really just want to say some very general things and then flag a couple of issues that we'll probably be talking about. So the general theme is, my main theme is, I fear, and I'm sad to say, there's enough of a kernel of truth in that assessment to make this endorsement of President Obama's policies from the right, to make it troubling to progressives, you know, myself included. And I say that for three reasons. One is the stakes involved, because there actually is something of double standard for the Obama administration, but I think it's something that he actually can't do anything about. And the double standard is this. Short term, I don't have, you know, many worries in the sense that whatever the claims are, the legal claims and other claims are, you know, I know a lot of the people in the administration. I have a relatively high confidence that there are good faith efforts to do the right thing, broadly speaking. But the precedent set by whatever claims they make really set up some potentially dire long-term consequences in the hands of other less fastidious administrations. And so that's a real worry, which increases the stakes with regard to whatever this administration does. Which brings me to my second kind of introductory general point. And my second introductory general point is, you know, the record is mixed. It's mixed, it's complicated. I think there are certain areas where the Obama administration, by my lights, has done significantly better, other areas where there is a story of continuity to be told, and other areas where it's arguably worse. In fact, what prompted that was Mike Ramsey at an earlier Federalist Society panel that I was partaking in. That was and he's a moderate conservative scholar, that was the gist of his remarks about how the Obama administration not only continues the Bush administration policies, but if you're worried about executive unilateralism, it's actually worse. And I think, you know, one can make an argument in at least a couple of instances where there's some truth to that. And the final kind of general point, and then I'll flag kind of two issues where I think, and just one other sort of general idea about results, because I was thinking, you know, this is a complex picture about the track record, about the results. Is there any sort of general coherent theme? And I think the theme that troubles me, and at least unites some of the things that I've been looking at, is actually, unlike the previous administration, there is a claim to respect the law, the Constitution, international law, but that the interpretations of constitutional law or statutes that bear upon separation of powers or relevant international law are sufficiently problematic and sufficiently idiosyncratic that one wonders whether that move is doing more harm than good. And this, interestingly enough, is a point that Philip Alston makes as General Rapporteur for extrajudicial killing in his report on targeted killings. So if there is a unifying theme, that's one that might be worth exploring. Which gets me to just a third general thought about the Bush administration, and a set on the Obama administration. There you go. See? Federalists are right. No, it just shows you I've been spending too much time with them. Is, you know, motivations. Now, the kind of Federalist Society account, the John Yoo, Mike Ramsey, et cetera account is, gee, you know, naive, progressive Barack Obama was talking a good game, listening to all these ACS people when he was running for president, but once he faces the realities of power and how dangerous this world is, well, of course, he realizes that Dick Cheney was right, okay? Whereas I don't, I obviously disagree with that account. What I think is actually going on, and this is, I think, what the Times and Charlie Savage is saying, is it's much more something that Madison predicts in Federalist 51, which is that, the president is doing what presidents generally do, which is increase their power, attempt to increase their power, and attempt to aggrandize it. And I don't think even that is a conscious process. One thing I've learned from doing human rights kind of in many places around the world is even well-meaning executives tend to overreact because they perceive the problem as more dire than it is, and they also perceive the way at it is that the most efficient way at the problem of security is through them, unchecked by legislatures, unchecked by courts, unchecked by international law. And so I think two areas which we'll then continue to talk about, there are many areas that we can talk about this, but the two that really are on my mind are, as much as I supported the results, was the Libya incursion, which I think really does set a potential bad precedent for future presidents. And then secondly, targeted killing, which I think also creates very bad separation of powers precedents, compounded by a pretty mystical, I guess, or pretty Delphic interpretation of the relevant international law. So I hope those are things we can explore.
Thank you.
Great, thanks. Let me just say thanks to Dawn and Caroline, to the Brennan Center for putting on this event, to Marty for agreeing to manufacture some differences between us. Because I think we actually largely see eye to eye. So I actually, part of why I was so taken by this idea is because I actually think, especially with the election looming, that we really do face something of a crisis when it comes to progressive national security policy. And the reason for that is not just because of the trope to which Dawn and Marty both referred, but actually I think it's a trap. And I think it's a very clever trap, whether sprung intentionally or not by those of different political viewpoints from ours. And it goes something like this, right? So the departures from prior counterterrorism policies can be attacked as weakening our national security and therefore become an issue in the election. Continuity, right, as Marty suggested, vindicates the Bush administration and puts President Obama on the wrong side of Senator/candidate Obama, which will look really good in a series of election videos, campaign videos. And so therefore, right, it follows, presumably, that critics of the administration on national security issues are actually outside the mainstream, right, that we're so far to the left that we have no idea what we're talking about. And that defenders of the administration are, like the administration itself, hypocrites. And I think that's, that's a very nasty trap from which to try to extricate ourselves. So let me try. I think we have to bracket Libya and targeted killing for a second, just because I think those are the two places where there is the strongest continuity problem, and I think we can talk about some of the reasons why. But there are some very important differences that I think our friends on the right often tend to marginalize. Jack Goldsmith has a new book called Power and Constraint, which I would urge you all to borrow. Because I think it really, I think, conveys in very powerful rhetoric and in very powerful writing some of these themes. So I think there's an enormous difference between the separation of powers claims we saw during the Bush administration and the kinds of claims that you've seen this administration make, at least in cases where they've had to litigate it. So for example, we know the Bush administration, as Dawn suggested, repeatedly invoked this idea of a preclusive, exclusive executive power, right, that necessarily overrode statutes Congress had enacted to the contrary. The Bush administration took a very, very cynical view of the role of courts. We actually forget, we've come so far, we forget that in the initial enemy combatant cases, the Bush administration's argument was that it was a political question, right? I mean, that's how far we've come from the first round of briefing in Hamdi and Padilla in 2002. And also the relevance of international law. I think, folks are going to disagree about what the content of international law is as relates to these topics. The Obama administration at least tries to pay lip service to it. Whether they do a good enough job or not, I think is a harder question. My former boss is now the legal advisor at State. I don't necessarily see eye to eye on these things. Right, so, I think But I think those are three very big, more than rhetorical differences and more than semantic differences in the context of national security policy between the Bush administration and the President administration. So if that's true, how can this conservative narrative succeed? And I think the answer is because we've seen similar results. Right, that is to say, for the non-lawyers, for the public discourse, for the editorial writers, on the ground, things were coming out the same, right? There are still 150 some odd detainees at Guantanamo. We still have military commissions. You know, we are only growing the program of drone strikes and other forms of kinetic operations overseas. The war on terrorism only seems to be broadening and not contracting, even as hostilities in Afghanistan seem to wind inexorably to some kind of denouement. And I think the question is, why are we having the same results if this has been a different approach, at least legally? And I want to suggest three possibilities. The first is the role of the courts. So the Obama administration has not been hostile to the courts have been hostile to the Obama administration. Right? So there's a remarkable body of jurisprudence, for example, in the Guantanamo detainee cases, where the DC Circuit repeatedly chides the Obama administration for not arguing for enough, where the administration takes a relatively moderate position on a question of the role of international law or the relevant standard of review in a Guantanamo case or things like that. And the DC Circuit judges write with some dazzlement and bewilderment about how they can't believe the administration isn't arguing for more. Right? If those are the courts, you know, I don't know that we can blame the administration for actually trying to end up somewhere in the middle. The second piece of this is institutional inertia and defense, right? I think it's unfortunate that the Justice Department has adhered to a lot of the positions it has taken in prior national security litigation. The state secrets privilege is a really good example of one area where this has been true. The Justice Department's sort of categorical hostility to Bivens suits, right? So damages claims against federal officers arising out of constitutional violations. But I don't know that we can necessarily blame that as on a policy decision by the Obama administration so much as on the role of institutions in government, right? And that goes to Marty's point about Federalist 51. What I mean by that, right, is we should all expect the relevant institutions to take the separation of powers seriously, right? One explanation for why the Supreme Court was so interventionist in the detainee cases was a fear, especially by Justice Kennedy, right, that the separation of powers had actually broken down, that Congress wasn't acting in a manner that was institutionally responsible, that the courts had to do something. When it comes to individual rights disputes, right, I think we've always had a bit of a different mindset. And that mindset is that the courts actually have an extra special affirmative obligation to look out for those contexts in which ordinary political processes won't adequately protect particular groups, minorities, et cetera, right? This is famously the footnote 4 mentality from the Caroline Products case, the cornerstone of much of Justice Brennan's jurisprudence, among other things. Right, and so the court's performance, I think, especially the Supreme Court, over the last 5-6 years, suggests that much of the blame for the current state of national security policy rests with the courts as much as with the administration. So this is just one statistic I like to throw out there, right? The Supreme Court has decided exactly 3 national security counterterrorism cases since 9/11 that did not involve a detainee in some way, shape, or form. Right? The only reason why they took those 3 cases was because those were the only 3 cases in which the government sought certiorari. Right? The Supreme Court has not taken a single case that didn't involve detention of an enemy combatant, where it was the victim of the counterterrorism program who was actually invoking the court's jurisdiction and trying to get the court to review it. So against that context, right, I think we have to be careful to affix blame where blame is properly due, and worry whether the administration should be more active in arguing against these results as opposed to just passively accept them as they come up. And my last point, and then I'll shut up, is sort of the difference between law and policy, right? So, and I think this is actually the hardest piece for progressives, because we should disagree about what is the right policy, right? As between action X and action Y, what is the best thing to do as a policy matter? But that doesn't make it a legal dispute, right? If the question is the government's authority to act, I actually think there we tend to blur that distinction and assume that if we don't like what the government's doing, it must not be allowed to do it, right? So Hladik is a great example, the targeted killing case. I have a lot of trouble with Hladik, I think we all do. But if you frame it as, does the government have the right during wartime to kill a US citizen who is actively taking up arms against us? right? Then I'm not so sure we have trouble with the legal question, right? What we have trouble with is how do we know, right? What we have trouble with is why can we be so sure that Hladik is who the government says he is, et cetera, right? And that's not a substantive objection, right? That's a process objection. And so I guess, there's a lot to say about all of this. I suspect we'll say some more of it. But I think it's very important to not buy into the conservative trap, because I think it demeans the argument, right? And it's sort of, it's too easy for us to say, oh no, this is how we're different from the prior administration, and then have the conservatives say, well, but look at all the ways you're the same, and therefore we win, you lose. There's a lot more nuance here. I think reflecting on and recognizing the nuance is the key to actually understanding where progressives disagree on national security policy. So I'll stop there.
Great, that was useful. And in the spirit of ginning up disagreements, so I'll sort of project Jeremy Rapkin onto you. I guess I'd say 2 points that strike me, which is, one, I'm not sure how compelling I find the argument that because the Bush-Cheney administration, not necessarily in that order, staked out incredibly extreme positions with regard to executive. So in other words, that the president didn't need Congress to authorize military commissions, that these cases were not justiciable, that the fact that we should give too much credit to the Obama administration for moving off of something quite that extreme.
It's a strong
right. It is, so
it's the alternative.
Right. Well, I mean, it does, sort of create the issue is, will that be an alternative that comes back or not? But then, if that's true, it creates this kind of meta problem that we all kind of suffer with, which is, the right is not just energetic, but they're successful because they're energetic, but they're also successful because they stake out such extreme positions on one side, which then makes, everything else look less reasonable. And so, are we buying into that other kind of trap if we say, well, gee, at least Obama's not saying these cases are not justiciable, at least Obama's saying, the president doesn't have unilateral authority to do all this stuff. Wouldn't we be better to push from the left on the other side and at least start staking out what would be, not extreme, but reasonable positions on the left to make whatever the middle winds up being more reasonable. So that's one response. The second response is about the role of the courts, and it does. I'm inclined to do a judo move on that particular observation, which would be that, well, gee, if the courts are not going to be a source, except in the most extreme cases, for performing their functions in separation of powers and protecting individual rights and upholding the law and all of that, all the more reason that we want the executive to stake out, moderate positions. So to the extent that the Obama administration is doing the right thing in front of the DC circuits and trimming its sails and going against the Madison 51 insight, that's great. But my argument would be, all the more reason to do it in other areas. And that applies really, to Congress as well. So, why not veto the National Defense Authorization Act? And then getting to Libya, looking at why not go to Congress, for that. So that would be my kind of comeback to that dynamic, I guess.
So I think one of the things we have to grapple with, right, is as lawyers and law professors, how much of this conversation is just about Tony Kennedy, right? And what I mean by that is could the administration stake out such an aggressive opposite position when it already knows where at least the center of the court is on the big questions? What I mean by the big questions is this a war? Right? Does the government have the power to use military force? Right. Can it detain even citizens so long as they're captured on the battlefield? Right? And I guess, I wonder if, at least where the Supreme Court has answered the big questions, I don't know where the extreme left is, right, with regard to the administration. But let me
That's my job today.
There you go. But let me change the conversation a little bit, because I think this will help illustrate it, right? I actually think the most impressive example of leadership of this sort that we've seen from the administration is on DOMA, right, on the Defense of Marriage Act. And I don't mean to sort of change the conversation, right, but I think it's a relevant metric, right, which is the administration has, now taken the position that we should apply heightened scrutiny, right, to the Section 3 of the Defense of Marriage Act. It has received all kinds of political, resistance for that move. The leadership in the House of Representatives has decided to intervene on their own to defend the constitutionality of DOMA, right? And this is a federal statute that has nothing to do with national security, right? Suppose the administration were to take a similar position on the Military Commissions Act or the FISA Amendments Act of 2008, right? Or other statutes Congress has passed. I think that would be the easiest way to guarantee a Romney presidency. Would be to sort of abandon the sort of the principled left in favor of the perhaps correct but unsustainable position, right? And so I think that's what leads the administration to push for compromise. Now, I'm not happy with the compromise. I don't think anybody should be happy with the compromise, right? But the NDAA is a good example. This is the National Defense Authorization Act from last fall, right? The administration threatened to veto the NDAA. And I know that sort of doesn't look like much, right? But as someone who was sort of deeply involved in working behind the scenes on the NDAA, that had an enormous effect on at least some of the language, right? I mean, the administration was actually quite successful in watering down part of the NDAA because of the veto threat. Should they still have vetoed it? Sure. I would have loved if they had vetoed it. But I think it's another example of where the discourse is not where the law is, right? So what's the discourse on the NDAA? The discourse is, oh my God, Congress has authorized the indefinite detention of US citizens within the United States, right? That's exactly the opposite of what the NDAA does. The NDAA specifically doesn't address citizens within the United States. Where it's really problematic is overseas, and with regard to non-citizens. And so I think it's easy for conservatives to look at that critique and say, well, you guys are all wrong. Look, the Feinstein Amendment says this doesn't apply to citizens in the US, therefore the NDAA is fine, right? And it's a beautiful case of misdirection when no one's actually focusing on the real problem. So this is why I think we run into trouble when we sort of paint with broad brushes in this area, and I think more topic to topic sort of nuances is how we understand where the administration, I think, can rightly be criticized. And where I actually think, heaven forbid, we actually might commend them for working against really horrible politics to reach at least some degree of compromise. Not often, right? But once in a while.
Great. Well, now I am supposed to ask a series of questions, but I'm tempted to go one more round here. If you want to respond, because my first question is actually going to be just to throw out the detention issue and talk about the NDA, which I actually saw Jon Stewart, and I think I read in the New York Times that it authorized the detention of American citizens.
And Colbert did as the word.
Right. Maybe it wasn't Jon Stewart too, but I think they both did.
That clip number really well in my classes.
Very good. So why don't we just...
Well, I guess there's two arguments there, right? One is the latitude the president has with regard to legal issues, and to the extent there's a gray area, to what extent should the president stake out a civil liberties position versus a kind of executive hegemony, national security position, to the extent there's ground for legitimate disagreement. And then I think you're right, that is a kind of issue-to-issue thing. I think it comes up more on the national security executive side than I would like in terms of proper legal interpretation. And that to the extent it doesn't, the president in his capacity as chief executive of the law should be criticized. But then the backup argument is, but he's only doing what he could do politically, and politics is the art of the possible. And I take that point to an extent, but I think there are at least two responses to that, one of which I think involves the president, and the other I think is a more general response. The one that involves the president is the question of leadership. Of selling the other side. God knows that the Bush-Cheney administration was very good about stoking fears and doing what it took to energize their base and energizing more moderate folk to clear a path for their rather extreme use of the law. And so they really didn't have too much trouble, but for a few Supreme Court opinions and getting everything that they wanted. And even there, the Supreme Court, could have done more and, was only knocking out things that were really intolerable. I just haven't seen that on the other side. I haven't seen the Obama administration, I haven't seen people from the Obama administration and allies of the Obama administration make really two kinds of arguments. One argument is, the importance of civil liberties as too high a price to pay for security, depending on how you make the trade-offs, and too high a price to pay in terms of giving up what we are as a people and our traditions. And then the other argument, which is, or Rona is back there, so one thing that Human Rights First pioneered, which is, there's not always a dichotomy between security and civil liberties, that they can actually work together, and that it is a false dichotomy. And so where I fault the administration is on sort of expanding the political base on the left to clear space for, more legal arguments that way. And then the final sort of more general thing is, but I will admit it goes beyond the Obama administration, so it's, it's not just that the president can make a speech and snap his fingers and create, a popular base on the other side. That falls to us, and there is this sense that, have we done enough in terms of grassroots stuff beyond, litigation, to help create a kind of popular sentiment for civil liberties.
And I think a piece of that is I think the administration, at least for a time, although I don't think this is true anymore, felt like it couldn't actually find a middle position on the left that would satisfy the left, right? That it was all or nothing. It's like the song from Oklahoma, which didn't work out
I can
well.
sing it.
But actually, Marty, I agree with you completely about the leadership point.
So much for the.
No, but I mean, the DOMA example I think is a unfortunate example of the exception proving the rule, which is that the administration has taken very few stands like that. And just to illustrate that in the national security context, right? The 9/11 trial. Right, so, right, Attorney General Holder comes out and says, we're going to have the trial in New York, it's going to be awesome, well, not awesome, but, right, you have all these federal judges saying publicly, right, we can handle these cases, we want these cases, let us try these cases. And you have the Attorney General saying, yes, we're going to bring it here. And the second there is sustained political pressure, the administration backs off, right? And yes, it took a while to reach the final decision to have the trial in the military commission, but we all knew the second they backed off, it was over. Right? Because the second you step down, you can't re-engage on that question.
Right. And my only footnote there, and then just turn it back to you, is I don't still understand, maybe why he didn't fall back to an intermediate position, which is, okay, we'll have it in federal court, we just won't have it in Lower Manhattan with all the symbolism, etc. But, why couldn't it have been moved to a federal court somewhere in a more secure, area? And so it's not just folding, it's just folding completely.
I think it could have been, but just because I live in DC and am therefore infected by the inside the Beltway mentality.
Right.
So you guys may remember the trial of Casey Anthony, right? This is what gets news more than, national security policy. So there was an op-ed, I got a forward the day after the Casey Anthony acquittal. And it was an op-ed title. It was Anthony acquittal proves the case for military commission. And I was sure it was from The Onion, right? Wow, The Onion's being unusually clever today. And imagine my surprise when I opened it and learned that it was by Senator Mitch McConnell, right, the Republican majority leader of the Senate, or minority leader. Right? If that is the climate in which the administration is operating, I think it is terribly unfortunate that President Obama didn't take to the airwaves, right, and say, we need to have this case in a civilian court. I know some of you are going to disagree with this decision. Here's why it's the right decision. You don't have to agree with me. Just respect that there are reasons for this decision. That should have been the speech, right? And as opposed to quietly announcing on the Friday before Thanksgiving or after Thanksgiving, right? That we're getting rid of this case and going to Guantanamo, right? And I think that's where I think the administration has made a series of mistakes, right? Not on policy decisions, but on not trying to sell the case for the progressive vision. Yeah. And I think that's absolutely clear.
Yeah. So if I could just say one thing, and I'll turn it back to you, Marty. So now that you've raised the DOMA example twice, for the first time I had this feeling 2 weeks ago I was in New York for a DOMA conference at which I debated Charles Freed at Fordham. And so I was on a panel with Charles Freed, who was Ronald Reagan's Solicitor General, who said, the worst thing President Obama's ever done, and it's going to destroy the Department of Justice, but sitting on, so he was here, and over here is Dan Meltzer, who was President Obama's Deputy White House Counsel, agreeing with Charles Freed that I was wrong, that that it was a mistake for the Obama administration to, which just puts, and it was a hard question, and I was the strong guided leadership, President's guided leadership on civil liberties and civil rights, and the history of the Solicitor General doing that, challenging Plessy and all that. So, and this is an exception to the rule that Department of Justice as an institutional actor defends acts of Congress. But it's a high bar to not defend an act of Congress for the Department of Justice. So that kind of leadership can only, I think, be, and then exercised on rare occasion. At the end, several very liberal law professors who will go unnamed, who are leaders on GLBT issues, came up to me and said, I'm not sure you were right to me. You great try, but it's a hard question. It's interesting, and so I think a lot of, like, on the state secrets, Bivens, all that, having worked at DOJ, really difficult to get them to move on those kinds of issues. And, we tried in the 90s on some other issues, and I think OLC, some of my friends who got to work there, did try in this administration as well, but it's hard. It's really hard to shift from what has been the tradition to leadership role on individual rights when you're talking about those kinds of issues. So, but I'd like to just to stay really on this topic. I think that the president did show leadership in the beginning. I mean, like, just to talk about detention and treatment of Guantanamo detainees. I did get to work on the transition, and at day one, he really did try to make a tremendous break, right, from the Bush administration's broad assertions of executive power, and got in there and ordered end to torture and black sites, and released and rejected OLC's extreme views, flawed interpretations on with regard to torture, at least released those opinions, and tried to close Gitmo. So I think we can maybe focus more on why did that fail? Why do we still have 169 detainees at Guantanamo? And maybe that will help, figure out whether he should be trying to provide that leadership on other issues as well. Maybe I'll start with Steve, because you really have focused on the detention, the detainees of the issues we're talking about tonight.
Yes, my successful litigation.
Yes.
Which, by the way, is being argued in the DC Circuit next Thursday. We've got a really favorable panel too. Why did it fail? I think it failed for two reasons, and I think actually, well, two and a half reasons. So the first reason why it failed is diplomacy, right? I think the administration, when it comes to things the administration may not have fully appreciated on January 19th versus January 21st, right, would be the difficulty in repatriating the detainees, right? So, the Guantanamo population really has three big chunks to it now. About a third of them have been cleared for release, but there's no country where we're comfortable sending them, largely because of the current security situation in Yemen. Right, about a third of them have been slated for trial by a military commission. We'll punt that to the side for a second. And about 47 or 48, right, have been identified as these specific cases where long-term detention really is the only, from the security perspective, viable option. Say what you will about that, right? But at least two of those categories should have been reduced by now, right? And it's the two categories that haven't been reduced where I think there's the most justification for criticism, right? And so I think the inability to actually repatriate detainees, the big headline this week is we finally were able to release two of the Uyghurs to El Salvador, and those are people who were never actually a serious threat, but also I think, or any threat. But I also think by not acting decisively up front, the administration opened the door for Congress to come in, right? And so, it's a common trope now for the administration to blame Congress for passing these transfer restrictions, for interfering with the ability to transfer the detainees, for example, into the United States to be subject to continuing military detention. But if you actually look at the timeline, there was plenty of time for the administration to act before Congress ever started getting into this ballgame. And I think, they missed their opportunity. So the longer time went on without decisive action, the more that it was left to task forces and interagency review processes, I think the more ammunition the administration was necessarily giving to the Republicans, and to the Republicans in Congress who saw the opportunity to really start making it harder. So now it's almost impossible because of a combination of these problems, whereas I think the opportunity window was the first 6 months of 2009.
I actually agree with one caveat here, which is, no, I mean, and the caveat is just...
It's all Rahm Emanuel's fault.
Right. Well, the caveat is actually more an addition. It's not really a caveat, which is that, ordinarily most of my qualms with regard to the administration's policies have been not abiding by the demands of separation of powers. But I think a point you can make is actually, under a proper view of executive power, the president had the power to do a lot of this.
Certainly under the John Yoo theory.
Well, but you don't even have to be John Yoo. You could be me, is the point. Which is pretty much the other end of the spectrum. So in terms of transferring detainees, that strikes me as all something that's already been delegated to him or is within executive power. And so, in terms of the law, there was no reason for him to hesitate. If we're talking about law and policy, right?
But maybe that's the exact point, right?
That's bolstering your point. And then, I think that's the law piece of the point that I just want to break out. And to unpack your point on the other side, the policy point is, look, this is a guy who just won a landslide, and has both houses of Congress behind him. This is, if you take kind of Rooseveltian 100 days action here, you've got both the politics and the law lined up to essentially get rid of most of that population. Now, there are going to be these very hard cases, but at least it could have been greatly mitigated. And indeed, maybe even Guantanamo itself could have been closed down before Congress stirred. But then once Congress did stir, once you drag your feet, then Congress did have, so on the one hand, the president could have done it on his own, but then, which would have been Youngstown in the middle, right? But then once Congress says no, withdraws funds and all of that, then you're down at Youngstown and Loeb, and it's a whole different story in terms of the law.
And you have to make the Bush administration Article 2 argument to accomplish the policy objective.
At that point, right, which I think the cure would be worse than the disease.
Yeah, I think, politically, I think it clearly was no political capital on anything but healthcare, and the economy.
Right.
And I mean, that's the answer. And lost that window. And so before we move on to some other topics on detention and treatment of Guantanamo detainees, the other thing I wanted to put on the table is just the issue of accountability. And has there been an adequate accounting of the Bush administration abuses? And we've had some internal investigations at DOJ, for example, John Yoo and Jay Bybee. And in the news again is the CIA's, Rodriguez's destruction of the videotapes of the high-value detainee interrogations, waterboarding, and the decision not to prosecute there. The Senate Intelligence Committee is still investigating Van Feinstein. I'm not really sure what we're going to hear from that. But and then we have litigation, and Steve referred to Marty as well, the state secrets assertions and Bivens issues, which are not very successful. So how about the alternatives of still we hear calls for prosecutions still, and some kind of independent fact-finding commission. Is it should we have done it? Is it too late now? Where have we left executive power with regard to these Bush administration abuses for future presidents? Have we set the record straight, or are we, if Mitt Romney is elected or whomever 10 years from now, are we back at the risk of repetition?
I'll back into this with a story from 2 weeks ago. I was telling Cindy Ross-Steicher that I was in a meeting with the Secretary of State for Northern Ireland that the New York City Bar was hosting. And one thing that was on the table was there was this civil rights lawyer who had been murdered 20 years ago. And it had come out in drips and drabs with the government kicking and screaming that this lawyer had been killed with the collusion of the security forces. And it's a very high-profile case in a very small society. And essentially what the British government did in the fall was renege on its commitment to have a public inquiry into this lawyer's murder. And so, here we were Americans, saying, how dare you not have this public inquiry that we've been calling for under international standards for almost 20 years, and that you yourself agreed to with the Irish government, okay? Now, this guy wasn't smart enough to say, back at you, and so we just argued on that. But you see the point, right? Which is, especially from my perspective, as kind of an international human rights guy, I find this exceedingly troubling. One, because it just not completely, but significantly undercuts the work of people like Mike Posner, in DRL. Moving beyond that, it's just more generally troubling from a domestic point of view not to have accountability. This creates a culture of impunity, and this is one of the worst precedents to set when we talk about, kind of the next Dick Cheney down the line. This is what I was referring to when I talked about the potential dire long-term consequences. Now, what should have been done, what can be done, I think in terms of this might be a dichotomy between law and political space, right? I think there are all sorts of legal options, right? There could have been, I think, more aggressive DOJ internal investigations. I don't see why there couldn't have been a special prosecutor appointed. Get creative, although here you need Congress, but you might have been able to get Congress to do it in the early days, have some sort of special commission that wouldn't have been lining up for a criminal prosecution, but really something more along the lines of a truth commission. There's all sorts of, I think, legal options. The question was, were any of them politically feasible? I don't know. I mean, I think maybe in the very early days, but I'm not even so sure about that. But even then, I think that just biting the bullet for a special prosecutor, and just having some sort of investigation. And then if you wanted to bow to politics and say, look, we're going to defer any decision on prosecution, but at least we're going to have an independent investigation, at least would go a lot further than we've gone so far.
So I think that's right, but the place where I think Marty and I disagree, look, there's a disagreement, is, I think it's a little bit of wishful thinking, right, to expect a president who comes to office on the basis of such a profound political shift, right? I mean, the ideological space between the predecessor and the successor is so great, to go it alone on something like this, right? I mean, it's historically been Congress that has had the most successful role in exposing prior government malfeasance, right? I mean, the Church Committee, when it was the thing that finally blew the door open on the internment camps was the Commission on the Wartime Relocation and Internment of Civilians, which was a congressional commission. Right. It was Congress that passed the Civil Liberties Act of 1988, right? So, I think, yes, the president could have shown leadership, but I think it had to be, bilateral, not what I mean, but right, multi-branch, right? I think he needed Congress on board. And I think the mistake he made was not realizing that and not going there and not wanting to, not prioritizing that. But let me just say one more thing. Failing that, right? Failing that kind of accountability, the federal courts professor in me wants to say the answer is damages, right? Let's have a robust damages regime. And here I think we come back to my point about the courts getting in the way, right? So, if you guys want to read a scary opinion, read Justice Kennedy's concurrence in the Al-Qaeda case about the detention of material witnesses. Because Kennedy goes so far to say as, in national security cases in particular, we should hold executive branch officers to an even lower standard when it comes to knowing what the law is and violating the rights of individuals. No one joined that opinion, but I doubt that's because there aren't people who agree with that mindset. So what could the administration do? I think what the administration could do is they could take less of an aggressive position in opposing some of these civil suits, right? So Jose Padilla just filed a certain petition earlier this week. This is the claim challenging his detention and mistreatment while he was detained as an enemy combatant. The Fourth Circuit opinion that said he couldn't go forward with his damages claim is so sweeping and so broad, one can hope the court will pay attention. I'm not optimistic. There's one example that really good. There's one example of the Obama administration actually supporting civil liability for torture. There's only one. This is a state law tort suit against the contractors partly responsible for Abu Ghraib. And the administration filed this amicus brief that took this remarkably dancing on the head of a pin position where they said, well, because in 2004 these contractors could not have been prosecuted because we didn't have extraterritorial jurisdiction over them in 2004 because various statutory problems, we'll support civil liability here, but not again. Right, but not now that they could be prosecuted, we don't need civil liability. So even where the administration found a way to support civil liability for torture, it was on such a narrow ground that the entire en banc Fourth Circuit had a lot of fun screaming at them at the oral argument.
I just have a quick but sort of meta addendum, and I just wonder if we're either painting ourselves into a corner or whether we're on the horns of a really big dilemma, right? And it would be this, sort of my argument would be, and I just expanded to Congress. Look, if the courts are not going to serve their, Federalist 51 function as a check, nor is Congress, right? Then, my argument earlier was all the more reason then for the president to show restraint, etc. But here's where the dilemma gets even higher. If the political atmosphere is such that the president can't do that, then where are we? And I'm not sure I have a good answer to that, but at least out of the course of this discussion, this is a dilemma that's striking me. So.
And I think that's why we are where we are.
Yeah.
Right? I mean, I think that's exactly why we are where we are.
Okay. Well, I was going to ask about drones in Libya, but I think we should open up and hear what you would all like to ask.
So you can ask about drones.
Just to tell you what I didn't ask about. So I do want to say I think Libya in particular is I think Libya and the War Powers Resolution is a great illustration is the illustration, I would say the one illustration of your point about commitment to rule of law and acting with an authority, but then interpreting the law in a way that that is the one issue that I have spoken out on publicly and criticized. But I do, I've had the same experience with Michael McConnell recently on a panel on Libya where they say Obama is worse than Bush in terms of not complying with the rule of law, and Libya is the first example. And then they mainly, I think it's, they all have the same list, but I do think that the others on the list are actually, it's not drones, but the others are distinguishable and just not, they're more like in the vein of the Charlie Savage article in the New York Times. But so I do want to talk about Libya, because I do think that is very troubling.
Yeah, I'll just talk about Libya briefly, and even more briefly just say something about how targeted killings fits into this pattern. Because so the kind of tentative thesis, I floated was, is it worse rather than to completely reject an area of law, to embrace it, but embrace it in such a way that it renders it not only kind of meaningless, but a bad precedent. And so, I think the Libya aerial bombing is an example of it. Now, look, as a human rights person, it's great that the Security Council uses an example of R2P, and, that we got this horrible dictator out of there, et cetera, et cetera. Okay, we'll see what, unfolds in the country. But the process of getting there, and I'm going to collapse just the constitutional and war powers, I call it the War Powers Act, even though it calls itself, it's an act of Congress. It's meant to track the constitutional argument, and so just on statutory text, the argument is, essentially it boils down to because it was limited in scope and in terms of the way it exposed Americans to harm, and limited in terms of the ordinance. It was so limited, the War Powers Act wasn't triggered, and so the Declare War Act wasn't triggered. And what's the magic word? Hostilities. It says, Congress needs to get involved after 60 days plus 90 days when the president introduces troops into either hostilities or imminent hostilities. But that's not all it says, right? There are actually two more provisions that are even less close to war. One is flying airplanes, etc., equipped for battle, or bringing troops equipped for into the territory of another country, right, without even shooting, without even hostilities. And then the final thing is something analogous to World War I mobilization, right? If you're just sort of massing troops on the border, that's triggered. So for the administration, and again, I love Harold Koch too, but for the administration to argue that that wasn't hostilities just was daft to me. Doubly so when you get to the sort of purpose behind the War Powers Act and the purpose of the Declare War Clause, which is look for any kind of significant military operation. And I would argue that when you're helping bombing another sovereign country, that qualifies. You need Congress involved. You need the sign-off from Congress. And so, I think, now, for whatever else, Bush went to Congress for, the first Gulf War and with the AUMF. And so, and the other thing is, it's not clear to me why Obama had to do that, because it seemed to me that, again, there was a window of time when the congressional leadership in the House and Senate, both Republican and Democrat, were on board with this. So I'm just still mystified by that move, both politically and legally. Maybe you could say, now quickly with targeted killings, there kind of my beef is more on the international law side. And I won't go into the theory about why, based on original intent and other things, the president must take care that the laws are faithfully executed, and one set of those laws is customary international law and the laws of war, even though I just said it. The content of the laws of war, and I think here it's worth looking at Philip Alston's report as Special Rapporteur to the UN, is the claims that this is in fact a war. I mean, what Steve said begged a lot of questions.
Right.
Is it a war when you are shooting civilians, American or not, in countries like Yemen rather than Afghanistan and Iraq? Are they directly involved in the hostilities, which is the standard you need to satisfy when they're just on the internet saying kill Americans, right? There are all sorts of questions about whether this actually comports with the laws of war. And again, I think for the president to say, oh, well, look, here, we're doing it. This is, unlike the Bush administration, we're taking the laws of war seriously, but we're just not going to release the memos and we're not going to give you much of an analysis about it. It sets a very bad precedent.
So let me take the 2 points backwards, because I think it'll make more sense that way. So on trying to kill, let me be clear, I wasn't saying, I believe it is a war, I believe you can get from A to drone strike. But that if you believe you can, it's a process question, right? And so I think, I share your concern about the international law question. I'm terribly concerned about the process question. I mean, for the Attorney General of the United States to give a speech where he says due process is not a requirement of judicial process.
Well, that's the domestic side, isn't that?
I mean,
yeah.
if before that speech, if you had given me a list of 14 attorneys general and asked me and asked who said that line, right?
John Mitchell.
Holder would have been 15, right? Or well, actually, maybe not. Right, but so I think that the problem.
I'm gonna have to argue with you, but you.
But I mean, I think the problem with trying to kill a conversation is that I think it's because the OLC memo isn't public, we can't have the real conversation. Right. And what I mean by that is, I think it's it's easy for me to say, if all these things are true, can't we all agree that the government have the power to do it, right? How do we know those things are true, and how are we convinced that the government isn't making false promises? And I think, to me, that's the ballgame, and I think that's where the administration has been alarmingly similar to its predecessors. With regard to Libya, I don't disagree that much about Libya. The only thing I'm going to say is, it's not as if the War Powers Resolution has been faithfully adhered to ever, right? And so for the critics of of Harold's memo, I agree with the criticism, but how is Kosovo different? Right? And in Kosovo, you actually had an attempt by Congress to affirmatively repudiate the action, which led to a tie, right? And the DC Circuit decision came up with Clinton, right? So I agree that the administration was perverting the War Powers Resolution. I'm not sure they were perverting it any more than any other president has. But that's not to commend it, right? But there's a horrible irony here. So at the same time this conversation was going on about Libya, you were also seeing the beginning of the conversation about the NDAA, and you had the same members of Congress saying in one room, oh my God, I can't believe the president is exercising this power without our approval, and another room saying, we want to give the president the power to go to war with every terrorist group in the world, even though he doesn't want it. Right? I mean, it's like, that's why I don't know how much we can blame the administration for the perversity that is the politics of these kinds of discussions. But, maybe that's just because I live in Washington.
There's just one follow-up on drones, and then so the idea that it should be courts reviewing, I'm not really sure what you meant when you said that that Holder's statement was
Perverse
and horrific, right? Number 15 on the list. But and I want to ask you that. But I agree with the point about not having enough information, both parts of the OLC opinion that can be released, redacted, or an adequate substitute, right? A substitute, a white paper, and maybe even more the process that we need more information about the process being followed. But the judicial piece of it, I don't completely understand. And since you're in agreement on this, I'll just ask: there is not a FISA court-like process in place now for Obama. And do you think that was going to be my question? Should there be something like that before every drone strike? You have to go to a court, and if so, Congress needs to create it. You know, what is Obama supposed to do in the absence of a process to get that kind of judicial review? And I do think it is the kind of thing that ordinarily you would have process within the executive branch.
I'm sure there is process within the executive branch. I'm sure all the people all the way down the line take it really seriously, right? The problem is not that there isn't process. The problem is that we can't, no. But with regard to courts,
But the judicial
so let me go there. So I think ex ante review would actually be a perversion, right? Because I think ex ante review would actually have the effect of legitimizing all cases, right? And this is why I didn't agree with Alan Dershowitz's proposal that we should have torture warrants.
Right.
But I think damages suits, right? They're not perfect. They're not gonna succeed a lot of the time, right? But what litigation would come from that context is the requirement of deterrence, right? And the notion that the government actually has to try to get this right, or at least act reasonably in this field, right? And so, there are going to be problems with damages suits. You're going to have state secrets issues. You're going to have Bivens problems. If Congress really cared, I don't know why Congress doesn't create a limited statutory cause of action, for these kinds of issues. They've done it before, right? The Foreign Intelligence Surveillance Act has a cause of action for violations of the super secret process. It may not be effective, but I think it would be better than nothing.
Yeah, here's my difficulty on this, which is I think the analysis and the practicalities completely diverge. So the analysis would run something like this, where it is a war, or at least a conflict. I think the administration's position is it's a conflict not of an international character, okay? So it's a common Article 3 conflict. Where one can say that that's the case, and I think you could say that's the case, say, in Afghanistan clearly, okay? Then you get to kill people, it's a conflict, right? But, what about if it's Canada, okay? Then there's a pretty good argument that it's not, and at the point the international humanitarian law runs out is the point where domestic constitutional civilian strictures kick in, right? And then, and that's where, conceptually I would say, how can it be if we're in the realm of domestic constitutional law, we allow the president unilaterally to, target individuals.
So just citizens.
Because I don't think the due process clause says person. And I think one thing that I think is incredibly unfortunate in what's been going on, and I think I mark it to Hamdan, is I think there's some originalist basis, but I think it can be distinguished. I think textually there is no basis to say that due process rights are confined to citizens and not to non-citizens. And I think that's a very dangerous path to go. So that's just my views on that.
Although we're pretty far down that particular path.
We're pretty far down that path, but I think that's just a very wrong and erroneous and dangerous path. But so nonetheless, even if it's an American citizen in Canada, it's still going to be constitutional strictures. Then the question becomes, is the Constitution extraterritorial in operation? Another big conflict, I would argue, of course, that it would be. And then, how do you allow the president to target citizens, in Toronto for death, without some check from the other branches? Now, here's where the politics and practicalities kick in. I think there would be this, you couldn't get a FISA court analog through Congress, and even if you did, it would wind up legitimating rather than checking. And so, I'm really at a loss. I clearly am troubled by this in terms of analysis, but in terms of what to do about it. Other than,
to defend meekly the Bivens suit that Hladik will bring?
So, or at least, or the other thing would be just executive against self-restraint, which is, and I'm not sure there'd be a political payoff, there'd be a political cost for this, in the sense that, you just moderate your claim about when and where you can exercise unilateral authority to target people for death. And maybe that's the answer.
All right.